Can you hear me? Please tell me. Yeah, thank you. I think all of you should be able to hear me. If there's any problem, please let me know. First of all, you can see my photo years ago. My name is Martin Ko. So I will start at 7 o'clock. So many years ago. Chen, you man, you say no sound. Why? I think other student can hear me. Wait. So we'll start at 7 o'clock. No need to take attendance. I don't know. It's a housekeeping matter. Don't check in. You say you can't hear. Already recording function. Please look there. This lesson is now being recorded. It's being recorded. So don't worry. So it's already recorded. It will be uploaded to Soul. So if you either you miss this lecture or you want to hear again, usually there's no problem. If there's anything wrong, please let me know as quickly as possible. Okay. I will check the chat room from time to time. First of all, so please make sure that you have all the necessary material. Right? Learn Mei Fong, you say low sound. You can't hear anything. Wang Miu Yu also say you can't. I already switched on my microphone, so that may be left up corner. Try to left. So what does it mean? Okay. Where? Okay, so now, can you hear me? Oh, low sound. So why? Some students can hear me, some students cannot hear me. I don't know whether it's the problem of your computer or iPhone or most students can hear me. Yeah, very good. Okay. So we'll start the lecture now. First of all, this is a message from lecturer. So it's our first lesson. So welcome to CLS. The first year of study is called CLS, and the second year is called DLS, and then ADLS. So it's your first step in legal study. In fact, I have taught this module for more than 20 times. I simply cannot count how many times I have taught this module. Okay, because I think the first time should be in say 2000 something. So I'm already very familiar with the content. So usually I will also update the workbook. So we have the PowerPoint and also we have the workbook. So I think the workbook is updated once every 3 to 4 years. Usually it's me to update the workbook. So I'm very familiar with the workbook. In fact, it's a quite easy subject. Just enjoy it because the examination, everyone agree. So it's the easiest one. So because it's the first module, it should be something quite easy. Otherwise, you lose interest in legal study. So it's the reason why it should be a quite easy one. So make sure that you have all the material like the workbook, study plan, lecture notes of chapter 1 or other chapters in the future, essay, grading matrix, and ILO. It means income, intended learning income. Intended learning outcome. Okay. So I will go through all of them very briefly before I start the lecture. Also make sure that you remember the day for each lesson. Usually we will have lesson on every Tuesday and Thursday. So of course it's very sorry we have to use online teaching simply because of the coronavirus. So please raise any question in the chat room. But please know that I'm not able to answer the question immediately because it will disrupt my teaching. So I will only answer your question during the break or after the lesson. Usually I will have a break at around say 8:20 for 10 minutes. And then I will end the lesson at around 9:49, 9:45. So after 9:45, you can ask any question you like. I will stay behind for around 50 minutes so that you can raise any question. But if you cannot raise any question during the lesson, so you may also send me email. My email address is martin.co@hkuspace.hku.hk. So I will answer the question, reply to you as quickly as possible. So the second lesson is on this Thursday. Okay. And so also a very important thing is please do all the activity. Usually when we have in-person lesson, so I will distribute a answer book. But of course now you don't need any answer book. You may just write down your answer on any paper you like or even on your lecture notes. So usually I will prefer to have a hard copy lecture notes. But of course it's up to you. So some students may like to use a soft copy. You can type any comment, any remarks on the soft copy. Is up to you. So I think different students will have different habit. It doesn't matter. Right. So I say don't check in say you will end. But I only say that I will end the lecture at 9:45. I will stay behind for a further 15 minutes. So for students to raise any question. Because some students may think that it will be too late. So if we end the lesson at 10:30, it may be too late. And also I have to leave because now I'm having my lecture at my office. Right? Usually our colleague will come to ask me to leave at around 10 p.m. So I won't be able to stay behind after 9 p.m. Because I will disrupt so the life of my colleagues. Right? So I have to leave at 10 p.m. Right? Where should I upload the C? I think please ask the say I think the admin assistant. Okay. The lesson I will end at the teaching the lecture will end at 9:45. Okay, I will stop teaching at 9:45. But you may still ask me question. And then I will try my very best to answer the question. So I think before 10 p.m. Okay. First of all, I have to introduce myself. My name is Martin Ko. So it's a photo I took in JP Morgan many years ago. Okay? Just call me Martin. No need to call me Mr. Ko. Okay? So for academic qualification, I got my LB, PCL from Hong Kong U, and then I got my MB degree from University of Nottingham on a full-time basis. I studied there in England, in Nottingham. And also I spent several years to study for a Bachelor of Law degree in Chinese law in Peking University, but it's only on a part-time basis. In fact, I did not go to Peking. Okay, I stay in Hong Kong. Because it's only a part-time program. Right? The other one, professional qualification, solicitor of the Supreme Court of Hong Kong. I'm a qualified solicitor. Okay. So for a law lecturer, there's no need for him to be a qualified lawyer. But I'm a qualified solicitor. But my career mainly on in-house legal counsel. I think the job is quite interesting and also challenging. I work in so many reputable corporations, including the Mass Transit Railway Corporation, Great Eagle Group, and also Weldon Group. The last job I took was being the Deputy General Manager of the Company Secretarial Department of the Henderson Land Group, Currently, I'm a Hong Kong U-based law lecturer. So I'm also an adjunct associate professor of Chinese U. I also have my own company. So I've got a lot of teaching award. In Hong Kong U Space 2008, 6, and also 2013. Also faculty teaching award in so many years from CU Hong Kong Business School. I taught in so many institutions, not only Hong Kong U Space, but also Chinese U Hong Kong, and also CU Shenzhen, Shenzhen 中文大学. Okay? So from time to time I go to Shenzhen to teach students in mainland China. For subject I have taught contract law, tort law, land law, etc. So most of the law subject, I can teach so many law subjects. And also many institutions, including Hong Kong U Space, Chinese U, CDU, Tsinghua U, etc., etc. Okay, so it's my CV. So I think I hope you will have confidence in my teaching. I try to make it more funny. So I think law, in fact, is something quite. Many people think that law is something quite boring. But I try my very best to make it more interesting. So for every lesson, we will refer to the study workbook. This one is the study workbook. So please make sure that you have this workbook. In fact, you don't need any other thing. So we'll now go to the teaching plan. So these are the chapter we'll go through. So we do not bother to go through them in detail. I think the most important thing is assessment. So we only have one assignment. Please note that we only have one assignment. I think all of you have already received the assignment. Later on, I will explain to you the contents of the assignment. The assignment will account for 25% of the final mark. on this course. But examination should be something more important because it will account for 75% of the overall grade. Altogether, we have 10 chapters, but they are not evenly distributed. Some chapters are very short, some chapters are very long. For example, chapter 6, chapter 7 are very long. We need 1.5 lessons on each of them. Some are very short, like chapter 4 or chapter 2. So no, we don't need one lesson for each chapter. Of course, I will tell you the progress from time to time. We try to make it more interactive, but of course we have difficulty because now we are using online teaching. And also more important matter is the reading list. In fact, I don't think you need any textbook for this subject. You don't need any textbook. The workbook, this one is already distributed to you free of charge. So it's more than enough. As per my advice, the workbook is more than enough. Okay, I appreciate that. Usually at the very beginning, students are very enthusiastic. They want to know more. But in Hong Kong, the difficulty is that we don't have too many textbooks. Okay, why? Because we only have a very small population of law students. We only have 3 law schools. Very small number of law students, so the publisher does not have a great incentive to publish a law book for law students. And also some law book they are for LB students, so they are not for diploma students, certificate students. So I think the workbook is very suitable because it's tailor-made for students of CLS. It's more than enough, what I can say. So my advice is that there's no need to buy any textbook. So later on, I think you agree with me. Okay, you'll find this workbook is more than enough. Of course, we can also refer to some website in order to get more information. Later on, I will tell you some website which is relevant to this module. But for each lesson, I will have a PowerPoint. And also we'll refer to the workbook from time to time. So please make sure that you at least you must have the PowerPoint and also the workbook, and also preferably you should have the hard copy, especially for the workbook. I think the hard copy is more convenient. And also we'll go through very briefly the grading matrix. This is the grading matrix. Is a description for different grading. So usually we have excellent, good, average, and also below average. And also we have the learning outcome. So this is the intended learning outcome. As a formality, we have to go through the intended learning outcome. So first of all, to describe the principle, classification of law and legal system. So in chapter 2, we will learn how to classify the law. What are the major classifications? Altogether, we have 6 classifications. Number 2, summarize the key feature of the lawmaking process, which is, say, lawmaking. Sometimes you also call it legislative process. Number 3, describe the structure and function of the different courts in Hong Kong. So later on, you'll find we have so many courts. So you simply cannot find so many courts in just one city. It's something very unique. So I think in so many different countries, so many cities, you simply cannot find so many courts, just like in Hong Kong. Number 4, explain how judges decide case and also make law, which is called judge-made law. Sometimes it's also called case law or common law. Okay? And so we have to learn the rules of binding precedent. So because the judge usually we follow cases in the past. We call this principle as rules of binding precedent. Statutory interpretation, it means how to interpret, how to explain the legislation. So number 5 is the legal profession. Again, Hong Kong is quite unique. Because we have solicitor and barrister. We have 2 separate branches. of the legal profession. Number 6, identify the appropriate step and requirement for applying for legal aid. Legal aid, the system is just copied from England. We copy the legal aid system in England. So we have the legal aid department and also some say organization providing legal aid to citizens of Hong Kong. I will study this topic in chapter 10 of this module. This is what we are going to study. Now we will start with chapter 1. For chapter 1, is introduction to law and legal system. So we will spend the whole lesson on this chapter. So in the next lesson, we'll finish chapter 2, and then we'll finish half of chapter 3. Because chapter 2 is a very short chapter, so you don't need one lesson. But chapter 1 is quite long. Later on, you will also find a lot of activity. The feature, the characteristic of this module is that we will have a lot of activity. Okay? So you have to do a lot of activity. You have to answer a lot of questions, and then I will ask some students to answer the question. So which will make our teaching, our study more interesting. So you should not just listen to me. You have to participate in the activity. You have to do the activity. You have to answer those questions in the activity. First one, chapter 1 is called Introduction to Law and Legal System. So I will teach you some basic concept, and also you learn the different component of the legal system. First of all, so when you study law, usually if you tell your friend you are going to study law, what's the response of your friend? Most of your friends will say, "Oh, law is boring. You have to memorize so many things." Of course, to a certain extent, they are correct. So you have to memorize a lot of things. You have to memorize a lot of cases, legislation. And when you become a lawyer, you also have to memorize the facts of the case, what actually happened. But memorization is not enough. Right? Why? Because usually, for people who have legal problem, usually what do they want? They want to have legal advice and also assistance. People that a law client will come to see you. If you are a lawyer, a law client will come to see you. What are the sources of law? So what is Chapter 32? What is Section 5 of Chapter 32 of Laws of Hong Kong? No one will ask you this kind of silly question. Usually, what question they want to ask? Your client will come to see you. Your client will say, "Oh, I want to divorce with my wife. So what should I do?" Okay? What should I do in order not to distribute my money with her, so that I can keep all my money, all my assets? So your client asks you, I signed a contract. Last week, I don't want to be bound by the contract. What can I do? These are the problem of your client. Okay? So they are seeking legal advice. They are seeking legal assistance. People that when you are going to assist them, for example, if you are going to draft a legal document when you represent your client in the court, it's called legal assistance. It's very different from legal advice. For lawyer, after they have made legal advice, they will also provide legal assistance to the client. Okay? So how can you solve the legal problem? How can you give the legal advice? Okay? How can you prepare the legal document? You simply cannot just memorize everything. Even though you can memorize every cases, even though you can memorize all the legislation, you cannot solve the problem. Okay? If you want to solve the problem, you must have legal skill. Okay? Analyze the case, apply the law to the fact, and give appropriate conclusion and advice to your client. But how? How can you get the legal skill? Okay? Just like cooking. Okay? So if you want to cook, if you're going to cook well, can you just memorize everything in the cookbook? Even though you can memorize every word in the cookbook, you cannot cook the food well. Why? Because you must have the skill. Okay? You must acquire the skill. How can you get the skill? It's through learning. Learning, right? You have to learn. You have to learn how to acquire the legal skill. So what's learning? Learning is an activity that develops core capability, which include acquiring knowledge by doing the task in this workbook. You have to do the activity just like cooking. You have to practice from time to time. You cannot just read the cookbook. You cannot just memorize every word in the cookbook. You have to practice. You have to develop the skill. Okay, you have to prepare, practice cooking, say different food. Okay, whether it's spaghetti or whether it's a soup or some other thing. You have to acquire the skill. So this is the step you have to say you have to do when you are approaching a legal problem. First of all, you have to analyze the fact. So when your client come to see you, he will tell you so many things. He will give you some document, he will give you some photo. So you are given a lot of data. But if you want to give advice, you have to analyze the fact. You have to organize them in an orderly manner, right? And also you have to identify applicable law. Applicable law means what law subject is relevant. Is it contract law, company law, or family law? Of course, when you study law in this program, usually the law is confined to one law subject. The law is confined to company law, the law is confined to contract law. But in practice, many problems will involve different subjects. Many transactions, many legal problems, they will not be confined to just one law subject. It will involve contract law, conveyancing, tenancy, listing rule, company law. Okay, so don't think that is something so simple. But as a law student, of course, we can't give you something so complicated. Number three, analyze doctrine. Doctrine, in fact, it means the chapter. The chapter in a law subject. For example, the problem is about contract law, but which topic? You go to see what is the relevant topic. It may be about vitiating factor. It may be about contents of contract. It may be about formation of contract. So this is the relevant topic or doctrine you have to study. It means rules in that branch of law. That's the, for example, the essential element of a binding contract. You want to consider whether there's already a binding contract. You have to see whether you can find all the essential element of a contract. After that, after you have found the legal rule, the relevant legal rule, because we have so many legal rules, you have to find the relevant one. And then you have to apply the rules to the fact. It's called application. Application usually is quite difficult. Because for many students, they know the law, they can memorize so many things, but sometimes they find it difficult to apply the rules to the fact. So application sometimes is the most difficult part of solving a legal problem. After you have applied the rules to the fact, you have to give the conclusion. For example, whether there's a legally binding contract. Whether the contract is already binding, so whether the contract has already been formed. This is the conclusion you have to give to your client. Okay, some is not easy. You see that from time to time you find some investment advisor. They have a lot of discussion, but they cannot give you any useful conclusion. For example, whether the share price will go up or go down. They won't give you any definite answer. They will tell you, either it may go up or it may go down. So they will give you very ambiguous conclusion because they simply do not know the conclusion. Okay, lawyers sometimes they're also the same. Sometimes they will not give you a very concrete conclusion because they are so afraid of giving wrong advice. But it's all, what you have to do. So your client will ask you, oh, so no, what's your conclusion? What should we do? You have to advise the client. So from time to time we'll use the term caveat. Caveat in fact is the Latin. It means beware. Beware, right? So it's the meaning beware, pay attention. For example, in sales of goods, we have a doctrine called caveat emptor. Let the buyer beware, right? Under common law, if you are the buyer, you have to check so many things. Usually the seller has no duty to tell you so many things, right? From time to time, we'll come across some Latin. But don't worry. Don't think that you have to study Latin. So I can tell you I do not know any Latin, right? Except those Latin terms in legal study. Latin is always used. It's very funny. Latin, 拉丁文 is always used in law. Why? Because Latin is already a dead language. The meaning of which does not change. So when a dead language, even though it's not popular in daily life, but it's something quite useful. Why? Because in law, the most important thing is certainty. For if you study law, if you draft a legal document, if you draft a legal treaty, if you draft some legislation, the most important thing is certainty. The meaning of the law must be exact and also certain. Okay? It's the reason why sometimes we use Latin. Of course, some scholar they use Latin. That's because they want to show off their knowledge. Just like classic Chinese. From time to time, some people will cite some statement or say a poem in classic Chinese. The reason is because they want to show off themselves. And also when you are solving a legal problem, something you have to bear in mind. First of all, there's no straightforward answer. Don't think that you can get the answer very easily. You have to go through a lot of steps before you can find the answer. And also you must have the legal skill. You must get the legal. You need the legal skill. You have to understand the fact. You have to analyze the fact, and also you have to understand the law. Result of the operation. That's the conclusion. It must be communicated to the client or other people orally or in writing. We'll use different language. Sometimes it's called legal language. Legal language is just like computer language. Right? Sometimes it's quite difficult to understand. If you have not received any legal training, you will find those language, you will find the law difficult to understand. First of all, we have to know the nature and function of law. I will show you some animation or picture. Some people say that law is like religion. Can you find the similarity between law and religion? Why law is like religion? What is the similarity? Any student? Any comment? Any comment on this statement? Law is like religion. Provide guideline to daily life record. Different kind of same core, yeah, good. Dictate our behavior and the way we live our life. Because they are very similar. Because both law and religion will tell us something we have to do, something we cannot do. We have so many do and don't. So in law, you have to do so many things. So there are something required by law. Under this ordinance section 25, you have to do something. Under this section, you have to do another thing. And also you cannot do something. Okay. So there is the reason why they are very similar. Sometimes law is like a tree because we have different branches. In law, a tree, of course, a tree has so many branches, and also in law we have the legislative branch, executive branch, judicial branch, different subject. We have contract law, tort law is each subject is subdivided into so many different topics. Law is like a river. I don't know why. Because law is developing. I don't think that law is static. If you study law in 1970, so your legal knowledge is already outdated. Because every day we have some new legislation. We have new cases. For lawyers, they have to update themselves. Just like a river. A river is flowing. A river is different from a pond. It's different from a reservoir. Okay, so it's flowing. So it's flowing, just like law. Law is flowing, is developing, is changing all the time. Okay. Also, law is like a multi-story building. We have so many components. So each case, each piece of legislation is a component of the legal system. While our legislative and judges, in fact, they like architect and builder. So for cases made by the judge, it's already a component of the legal system. For legislator to pass legislation, this is also another component of the legal system. Of course, some things are similar, but again, they are different. Why is law not religion? What is the difference between law and religion? Very good. Michael said there's something to rely on. Both have long history of development, also very good. But why law is different? Law is similar to religion, but why they are different? They are not the same. We cannot use religion to replace law. Law is enforceable on everyone, but religion is not. Very good. So for religion, you have the freedom. So usually in modern society, everyone has freedom of religion. You can choose which religion you like. You can choose not to believe in any religion. So law is based on fair. Religion is more static. Law is flexible. Law requires certainty. Yeah, very good. So all the answers are correct. Religion is moral. Very good. Michael. Religion is moral. It's about moral teaching. So law may be immoral. So it's not relating to moral study. Your law is something binding on people. No matter whether you like the law, you have to follow. So you don't have any choice. But for religion, you have the choice. You can choose to be a Christian. You can choose to be a Buddhist. It's up to you. But for law, you have no freedom as long as you are in Hong Kong. Even though you are not Hong Kong resident, you still have to follow Hong Kong law. You still have to obey Hong Kong law. Very good. To summarize, we can say that law concerns all people, no matter who you are, whether you're old or young, male or female, whether you're a policeman or whether you are a typist. So law concerns you. The function is to regulate the behavior of its member. It set freedom to our freedom. It set freedom to our action or inaction. I think everyone have very extensive freedom in Hong Kong. Freedom of speech, freedom of religion, but there's some limit to our freedom. It's usually prescribed by law. Law will set a limit to our freedom. So it's normative. Normative means it set a standard instead of descriptive. For example, see in some study is descriptive. They just describe the reality. It does not set any standard. But law is not only describing what is the reality. So it set a standard. This is a standard you have to reach. If you fall below the standard, you may be sued. Just like tort law. So we set a standard. You have to meet the standard. If you fail to meet the standard, you may be liable. Now we will do the first activity. Please go to page 6 of the workbook. So later on, so we'll see this is the format of our activity. Please go to page 6. This one is for question. We won't just ask you some simple question. We won't just recall what we have learned. Instead I will use some activity. Usually, first of all, you'll be given a lot of data. Data is some kind of raw information. So just like your client, when your client come to see you, he will tell you so many things. Okay? These are the data you will get from your client. Okay? The data is that you are a member of the Hong Kong History Club. Club was established in 1975. The club's constitutions provides as follows. The club shall be managed by a committee of 3 members. The committee shall have the power to do so and so. The committee has made the following rules. Okay? These are the background information. What happened is that the club has entered into arrangement with Cedar Swan, the owner of a garden adjoining the club premises, to use his garden between the hour of 9 a.m. and 6 p.m. every day except Sunday. Wong is not a member of the club. One of the club's members, James Chen, was recently informed of the committee's decision to require him to pay $10,000 after he was found in the garden with a lighted cigarette in his hand. Chen has refused to pay. He claimed that the club has no power to fine him without giving him an opportunity to be heard. That he has not broken any rules, and then even if he had a fine of $10,000 is excessive. So what is your task? Now you are given the task. Task means what you have to do. These are the job you have to do. Okay. First of all, the first task is that usually data can be organized into the following category. When you are given a lot of data, when people tell you so many things, okay, so you have to classify the data. We have 3 different nature. Some data are called fact. So fact means something factual. For example, John is already 20 years old is a fact. Rules means some kind of regulation. For example, you have to come to the office at 9 a.m. every day. Is the rule. Okay? So if you are late, you will be punished. Is the rule. So it's just like the school regulation. And also we have the opinion. Some statements are only opinion. They are not fact. They may not be true. These are only the opinion or some people, for example, your client think that it's excessive. Your client think that no, he has not done anything wrong. This is only the opinion of your client. It may not be something factual. Provide at least one example for each category. Go back to the data and find at least one example of fact, one example of rules, one example of opinion. Okay? For the purpose of this, you may assume that the data are true and that the facts can be proved. It's a very important thing. Very important concept. Later on, when you are doing some problem type question, especially when you are going to study contract law, when you're going to study tort law, usually you are given the facts of the case. Usually you don't have to dispute the fact. For example, the fact say that John is 25 years old. No need to dispute the fact. You have to assume the facts is true. Okay? You have to assume John is really 25 years old. Okay? No need to dispute the fact. No need to say I haven't checked his ID card, so I do not know whether he's really 25 years old. So it's something unnecessary. Please assume all the facts are true. Okay? Don't dispute the fact. No need to dispute the data. For example, when we say that the car was established in 1975, no need to dispute. No need to say that I do not know whether the club was really established in 1975. It's something silly and also unnecessary. Okay. And so, number 2, I'll take each individual rule and say for rules we have different possibility. Prohibition. Prohibition means that someone is not allowed to do something. For example, if you go to library, usually there's a notice say that no smoking, no drink or food, or okay, no disturbing other people, etc., etc. It's called prohibition. A requirement means that you have to do something. For example, you have to pay tax every year. You have to apply for a license if you are going to operate a restaurant. It's called requirement. Permission. Permission means something you are allowed to do. For example, you are allowed to borrow 5 books from the library. So it's permission. Okay. You may use the computer in the library. You may say no. You may do something. The law will allow you to do something. You are allowed to operate the restaurant after you have obtained the license. Okay? So you have to give one example for each category. The for the power, we have 3 different possibilities. Legislative. Legislative is making legislation. Judicial usually is settling dispute. Okay. So executive is something administrative. So you have to see whether, for example, making binding rule, whether it's legislative, judicial, or executive. Choose just one. Number 4, legal institution is an organization. So identify the institution that is part of the Hong Kong History Club. What is the institution of the Hong Kong History Club? Also, number 5, you may not know the answer. You cannot find the answer from the data. If you do not know the answer, it doesn't matter. Okay? So no, just write down anyone, the name of those people who advise on the law, the name of those people who adjudicate in a court of law, or the one who implement the law. For number 5, don't worry. If you do not know the answer, it doesn't matter, because you cannot find the answer from the data. Okay, now I give you say 15 minutes time to do the exercise. Please learn how to do the activity. Please answer all the questions in the activity. It doesn't matter if your answer is not correct. Doesn't matter. Okay. But the most important thing is participate in the activity. Answer all the questions in the activity. So it's what you have to do in order to acquire the legal skill. Okay. So now please do the activity. I'll give you 15 minutes time. Okay, so I think it doesn't matter if you cannot find the answer, but the most important thing, try your very best to answer all the questions. Okay? So I will go through the question one by one. First of all, question one, the data can be organized into fact, rules, and opinion. So first, can you give any example? You can find a lot of facts. For example, you are a member of the history club. The club was established in 1975, etc. These are example of fact, right? And also, so in this paragraph, you can find a lot of fact. Our club has entered into arrangement with Silas Wong. Silas Wong was the owner of the garden adjoining the club's premises, etc., etc. Wong is not a member of the club. One of the member I was recently informed of the committee decision to require him to pay 10,000, etc., etc. These are example of fact. Very easy. The second one is rules. So you can find so many rules. So altogether we have 4 different rules. Number 1, number 2, number 3, and also number 4. Opinion. Opinion is a quite important concept because from time to time we can hear a lot of statements, but sometimes they're only opinion. For example, you say, "Oh, the tax is so high," it's only your opinion. Okay, it's not something. It's not fact because whether the tax is high or low, I think sometimes it's not fact. It's only opinion. Different people have different opinion. Okay, whether whether the price is too high or too low is also opinion. Some people think that the price is very low. Some people think that the price is already very high. It's up to them to decide. Right? So can you give any example of opinion? For example, Chen claims that the club has no power to fine him without giving him an opportunity to be heard. Is his opinion. Whether the club has such power or not, it's something we have to find out. It's not given in the paragraph. We do not know the answer, but it's the opinion of Mr. Chen. And also, Chen claims that he has not broken any rules. The fine is excessive. All of them are only opinion of Chen, right? So it's not fact. The rules are whether they are prohibition, permission, or say requirement. So number 1, subscription. What's it? It should be requirement. So every member has to pay an annual subscription of $1,000 each. It's a requirement. Smoking is not allowed. It's prohibition. Prohibition. So no, he has to pay the sum of 5,000, etc. It's also a requirement. So if the member is found smoking, he has to pay $5,000 to the club. So number 4, members are entitled to use the club's library free of charge. It's so-called permission. Permission. So if you are allowed to use the club, if you are allowed to use the swimming pool, if the guests of the member may use the swimming pool, is only permission. Right? Then we go to number 3. Number 3, the committee's power. Right? We have different power. We use the example of history club to illustrate 3 major power of a government or country. So of course, so we use the example of history club because I think most of you have been member of a club or society, especially when you were in the secondary school or university or primary school. You join the music club, you join the drama club, you join the sports club, etc. You may even be the chairman of the club. So the club is a concept you are very familiar with. Of course, when you were in the secondary school, you did not know anything about legislative, judicial, or executive. But in fact, a club or the committee has different power. Okay. So first of all, making binding rules is legislative is legislative for making law, passing legislation, passing regulation, we call it legislative 立法 right hear and determine dispute between members sometimes they have complaint so some member complain that the fee is too high, some member complain someone is making noise in the club premises so the committee has to settle the dispute. It's a judicial process, okay? So manage the club is executive process. So in this model, I will focus on legislative and also judicial. We do not cover too much about executive process because executive process has very little relevance to law. Usually, so I think it's a matter of public administration or other discipline. So law usually will focus on legislative and also judicial process instead of the executive process. Number four is a quite difficult question. Many students do not know the answer. Legal institution is an organization with the power to make, administer, or enforce rules. What is the name of the institution of the Hong Kong History Club? What is the only institution you can find? For this one, you may type your answer. Committee very good. Michael said that it's committee. The committee. So for the History Club, of course, the History Club is a very small organization. It does not have very complicated structure or institution, unlike the Hong Kong SAR. We have the say Legislative Council. For judicial, we have so many court. Executive, we have so many policy bureaus, so many government departments, and also so many public body. The structure is very simple. It's only the committee. What kind of institution is it? Legislative, judicial, or executive? Do you think the committee is a legislative institution or a judicial institution or an executive institution? In fact, all of it are very good. So no, there's no separation of power. Okay, History Club is a very good model. No separation of power. 冇三權分立。Okay, so I think the Hong Kong SAR will like the History Club very much. We may use a committee to perform all the function, all the legislative function, judicial function, or executive function. So it's very sure that the History Club has low separation of power. The committee will do everything. Okay? Legislature, so is the person who pass a law. Sometimes we call it legislative council. 立法會議員。I say, what name would you give to a person who advise on the law? The person who advises on the law is called. What's the name of that person? A lawyer, a solicitor, a lawyer, counsel, or legal advisor, legal counsel. We have so many different names. Okay? Adjudicate in a court of law. Who's the person who adjudicate? Adjudication. 審裁 judge. Usually most people will think it's judge. But other than judge, we also have some other name. There may be some other name. For example, like adjudicator. Sorry, typing. Adjudicator. Okay, very good. Adjudicator. Because in tribunal, the tribunal, sometimes we use the name adjudicator or presiding officer. So we have different name for different people, and also magistrate. Very good. In magistrate, they are not called judge. They are called magistrate. In mag court. Okay, and also we have arbitrator. Later on in chapter 8, so ADR, alternative dispute resolution, we have someone who is called arbitrator, 仲裁員仲裁師 okay? So arbitrator is the person who make decision in arbitration. implement the law. Pull out the person to implement the law, 執行法律 to enforce the law. When you make law, you need someone to implement the law, to enforce the law. For example, if you do not allow someone to do something, there must be some person to implement the law. If there's no one to implement the law may be quite meaningless. Very good. All government departments, nearly many government departments are involved. Of course, the most important is the police, but other than that, we also have the immigration officer, custom and excise, ICAC, SFC, EAA, etc., etc. There are so many law enforcement agency in Hong Kong. Not only the police, of course, everyone agree. Police is the biggest one. Is the most important one. And also fire service, they also enforce some law. Even for some people, so they will also enforce law. Okay? So we have to list out all of them. Of course, in our legal study, usually we only focus on the police. Okay, that's all for this activity, and then we'll continue our lecture. So after this, we use the example of history club because history club is quite simple. It won't be so complicated as government. The example of history club is that we have to illustrate the fact that law is a relationship between persons. Okay? Why? Because so if there's only one person in the world, so do we still need any law? The answer is no. If you are the only one in the world, you don't need any law. You can do anything you like. But as long as we have more than one person, just like the case, if you are the only one in your home, if you are the only one in a flat, in an apartment, usually you don't need too much law. You can do whatsoever you like. But as long as you have more than one person, you need some regulation. Because you have to avoid disturbing other people. You have to avoid offending other people. Okay? So for relationship, we have two different relationships. The first one is relationship in fact, something factual. For example, John has bought a can of soft drink at the price of $4 in a convenience store. It's something factual. It's something factually happened. The other one is in law, relationship in law. We have to translate this sentence into legal consequence. For example, so they have contractual relationship as buyer and seller. It's the legal consequence. It's the relationship in law. When you study law, you have to find out the relationship in law. You cannot just say the fact. So fact is something used by people who are not lawyers and who have not received any legal training. They use this kind of language. But for lawyer, they have to translate the relationship in fact into relationship in law. Right? So it means that you have to find out the legal implication. For example, so altogether we have four important types of legal relationship. Duty. Duty is very important. So of course, duty is a legal duty is something legal sense. We are talking about legal duty. We are not talking about moral duty. For example, if you are a lifeguard, you have the duty to rescue the swimmer. But if you are not lifeguard, if you are only a swimmer in a swimming pool, usually you have no duty to rescue other people. So we are talking about the legal duty. Right, for example, the right to vote. If you are the shareholder, you have the right to vote in the AGM. You have the right to get the dividend. Power means some kind of authority. For example, if you are the officer, you are the police officer, you have the power to search someone in the street. You have the power to arrest someone. So when you reasonably suspect that he has committed crime, so you have such power. Okay? Number four, liability. A liability is a legal term. When you study accounting, a liability usually means the amount of money you owe to other people. 負債 In accounting, liability means some kind of money you owe to other people. For example, if you borrow $5,000 from the bank, the liability is 5,000. But in law, usually, we are talking about some legal duty in a negative sense. For example, legal liability for breaching a contract. People that in civil law we use the term liable. Okay. For example, if you breach a contract, we will say that, oh, you have legal liability. You will be legally liable. You will be liable. Okay. We do not use the term guilty. Guilty is only for criminal law. Okay. Don't confuse civil law with criminal law. I will use different terminology. A relationship. So for relationship, of course, it attached to person. If there's no person, there won't be any legal relationship. There must be more than one person. Okay. But for person, it's a quite difficult concept. In law, person does not only include natural person, 自然. For natural person, it's a very simple concept. All people who are naturally born, like John, Mary, say James or Peter, all of them are natural person. Okay? All of us in this classroom, in this class, all of us are natural person. Okay? But other than natural person, we also have artificial person. Okay? Artificial person is something very essential. The most typical example is company. From a legal perspective, a company is regarded as a person. Right? From a legal perspective. Why? Because company simply can do everything that a natural person can do. John can enter into a contract. A company can also enter into a contract. John can sue. John can be sued. Company can also sue and also be sued. Okay? From a legal perspective, company is not different from a natural person. That's the reason why company is regarded as a person from a legal perspective. So the most common example is company. Now please go to page 11 and do activity 2 and also activity 3. For activity 2, so we have A, B, C, and D. So which one is relationship in fact? Which one is relationship in law? For something without any legal implication, we call it relationship in fact. For something with legal implication, we call it relationship in law. Okay, A, law or fact. Very good. A is only fact because there won't be any legal implication. Basically, A, there won't be any legal implication, so it's also legal relationship of fact. So B, law of fact. Jackie owes Julia $1,000. It should be law. There will be legal implication. If Jackie does not repay the $1,000 to Julia, Julia may sue Jackie. Let's see. Jessica, we go to Japan with Michelle next month. Law of fact. C. C is only fact. There won't be any legal implication. So if Jessica does not say honor her promise, Michelle presumably could not sue Jessica. So it's only relationship or in fact, there's no legal implication. How about D? Peter has signed a partnership agreement with William. Of course, everyone knows that is law. Okay, so there will be some legal implication. Okay. And then go to page 12, right? Constitution of the Hong Kong History Corps stated that it's a mission to promote better understanding of Hong Kong colonial past. The club actively support educational research, publish research finding, and so on. Do you think the club is a legal person? Do you think the club is a legal person? Yes or no? Please look there. So now we may look at this very short look, right? This one. So in fact, so it means club. Club is usually formed under the society's ordinance. 會寫條例啊。Club and society usually they are not legal person, okay? So they are only a group of person. So club and society usually they have no separate legal entity, okay? They are regarded as individual person grouping together. So when a club is sued, all the members will be liable. So it's the danger of joining a club. You join a club, you may be sued. Okay, you cannot say, "Oh, it's not my fault." Okay, when a club is being sued, every member may be liable. Just like a partnership. But company usually they are formed or incorporated under the company ordinance. They are regarded as a separate legal entity. So it's called a legal person. So of course, I don't expect you to know the answer. Most students will give the wrong answer because you don't have the concept in company law. So when they register as a limited company, very good. Li Yun Ching. So when they are registered or incorporated as a limited company, they will be regarded as a separate legal person. So basically, for in Hong Kong, our club and society usually they are not separate legal entity. But for company, usually they are separate legal entity. Right? I think all of you are very tired, so please take a break for 10 minutes. After that, I will come back to finish the remaining part of this lesson of this chapter. Okay? Please take a break. Please take a break now for 10 minutes. Okay, so we'll resume our lecture. Okay, so for legal person, legal person or non-legal person is a quite difficult concept for many students. But it's a quite important concept. Because the most important difference is that if an organization is a legal person, it will be separated from its member, just like company. A company is separated from a shareholder or member. So if you're only a shareholder, Usually you are not liable. For example, you buy the share of a company. Usually only the company will be sued. You as a shareholder, usually you will not be liable. Because the company is a separate legal entity. The contract is signed by the company. Only the company will be liable. But if the organization is unincorporated, just like current society, owner committee, mutual aid committee, they are not incorporated. So when they are being sued, the member will be liable. Partnership is also a typical example. In a partnership, all the partners will be jointly and severally liable. Right? So of course, it's the law. Some people think that is unfair or unreasonable, but it's the law. We have to accept the legal position. If you don't want to be sued, you better form an incorporated body. For example, you form a company. And then we also go through some legal concept like legal capacity. Legal capacity is also a important but quite boring, concept. Right? So the question is how and when a legal person may create legal relationship. Right? For natural person, so the simple rule is that for adult, they have full legal capacity. Of course, all of you are more than 18 years old, you can sign any contract you like, you can buy shares, you can own property, you have free legal capacity. Capacity is in a legal sense, it's not in a physical sense. Right? So of course, you can always sign a contract. Even a child at the age of 10 can sign a contract physically, but the contract will have limited legal validity. For minor, for in law, we call people under the year of 18, we call them minor. It's a legal term basically. So minor means someone who is not yet an adult. He will have limited capacity. We will learn more in contract law. A company is also the same. I don't think that a company can do whatsoever it like. Sometimes company is restricted by the object clause in the Constitution, especially many government departments, many government organizations, they have very limited, authority or the limited capacity. So you better check the ordinance or the Constitution or a public body before you can determine whether that public body has the legal capacity. If someone is doing outside the object clause, it may be called ultra virus. You will learn more in company law. Don't worry. Usually we won't have any question on this issue. It's only a legal concept. So it means that the capacity of a company or a natural person usually is restricted. Legal status is also a concept you should be quite familiar with. The most familiar concept is marital status. Usually in the application form, there's a column say marital status, 婚姻狀況. You may either say single, married, or divorce. These are the three major marital status of a person. Okay? So legal status. It's a condition in life which is more or less static. For example, status or marriage. Right? When if you're a lawyer, if someone gives you a set of facts, you have to see whether the person involved are legal person. For example, John, Mary, of course, they are legal person. But if the party involved is an organization, you have to consider whether it's a legal person or an incorporated body. Okay? And also, if it's an incorporated body, you have to consider whether he has the legal capacity to create legal relationship. For example, if an organization has signed a contract, you have to see whether that organization is a legal person, whether that organization has the legal capacity to sign this kind of contract in order to create legal relationship. These are the issue a lawyer has to consider. So now to summarize what we have learned, we can give a working description of law. Law is a framework of legal rules. Please note there are so many legal rules, right? Sometimes the number is very big. For example, we have thousands of legal rules. So you have to group them together. So we call it a framework, a 框架. So no, we cannot study the legal rules one by one separately. It will be very confusing. For the legal rules, they are created or drafted. For case law, they are made by the judge. For legislation, they are drafted by legislator. They are made by those people who have the authority to make law. Usually, only person with legal authority can make law. Okay? Even the chief executive has only very limited authority to make law. So just like our chief executive, Carrie Lam, she has very limited authority to make law. Usually, most of law have to be made by the legislative council. Okay? And also, the law will control and facilitate a legal relationship between a legal person and also apply by person with authority. Even for a person who are going to enforce a law, he must have the legal authority. For example, to search a flat, to search a person, usually you must have authority. Right? So even though you know something wrong, the only thing the usual thing that you can do is to report it to the relevant authority. You report it to the police, you report it to the fire service department, you report it to the custom and excise. Usually you cannot take any action by yourself because you don't have any legal authority. You better report the case to the government, to the relevant government department or agency. So usually you are not advised to take any action because you don't have the legal authority. For how legal relations will arise, so we can say that it's an actual person So we have two possibilities, either by actual party. For example, John buys a car from Mary. They have contractual relationship. John is the buyer. Mary is the seller. They have contractual relationship. Sometimes it's by operation of law. So for example, a balcony fall from a building and injures a passerby. The no relationship between the owner of the building before the accident. But after the accident, so they would have some relationship, but the relationship is created by operation of law. Operation of law is a quite difficult concept to some people, even though you do not intend the consequence, by operation of law, there will be some legal consequence. Tort is the law we're going to study in Module 3. When you study Module 3, obligation 1 and obligation 2. Obligation 1 is contract law, obligation 2 is tort law. 民事侵權法 is civil law. So we are going to study this module in Module 3. By operation of law, it means that before the accident or incident, there was no legal relationship between the party. But by something has happened by operation of law, the two parties will have legal relationship. Right? Law as rule. Law is simply a set of rules, nature and function of rules. Law is general directive that prescribe the type of conduct required, permitted, or forbidden. Okay. So when you want to do something, you have to consider whether it's forbidden by law, whether it's permitted by law, whether it's required by law. Most of the act, so this one is the biggest percentage. Most of the law are talking about act forbidden. Okay? We do not talk about too many act required. The law does not require you to do too many things. Usually you have a lot of freedom. If you live in Hong Kong, there are only a few things you have to do. For example, to pay the tax, to follow the law. You have a lot of freedom. Usually you are not required to do anything. Right? So permitted. very extensive, but there's no need for the law to say that you are permitted to do something. Right? Usually, so the law does not tell you what is permitted. For example, if you want to the market, you want to go to the supermarket, there's no law to say that, oh, any citizen can go to supermarket. You cannot find any law to say that you are allowed to go to supermarket. Okay? So in law, in Hong Kong, usually when something is not forbidden, it is permitted. Okay? 除非禁止咧，你係可以做嘅。Usually unless you are forbidden to do something, usually you are permitted to do something. For example, you can go to Victoria Park anytime you like, especially in daytime. There's no law to say that you are allowed to go to Victoria Park. Okay. Also, for the framework, we have three different major framework. The highest one is called the constitutional framework. You will study in Module 5. That's the basic law. In Hong Kong, we do not have any formal constitution. So China has its own constitution. But in Hong Kong, we only have the basic law. Basic law, some people call it mini constitution. It's not exactly a constitution, but usually it's regarded as a document of constitutional nature. So we call it constitutional framework. It's about the state, the government. Okay. So other than constitution, the law is subdivided into two major categories. The first one is called substantive. Please note that substantive is not in contrast with something like virtual or online. Now we have a substantive shop and also online shop. We are not talking about this concept. Substantive law means duty and rights of person. For example, contract law is a substantive law. When you study contract law, you know the duties and rights of a person under the contract. When you study company law, you know the duty and rights of those people like shareholder, director. Okay, but other than substantive law, we also have the procedural arrangement or procedural law. You study civil procedure in Module 2, and also you also study criminal procedure in the second year. A procedure is not a very new concept. I think most of us will come across some kind of procedure. For example, if you go to the bank, you want to open a bank account, you have to follow the procedure. But usually in the daily life, we call it step. So instead of using the term procedure, we use the term step or rules or some other thing. Usually you have to go through some step if you want to do something. For example, you want to have a library card, you have to follow the procedure. You want to have a credit card, you have to follow the procedure. But usually the procedure in daily life is very, very simple. Opening a bank account is very simple. Even for borrowing money, it's also very simple. You don't need to go to the bank. You can do it online. You can do it through your mobile phone. Okay? But court procedure is very complicated, much more complicated than you can expect. You simply cannot expect how complicated is the procedure in legal proceeding or in the court. No, we do not only have a court procedure, we also have so many procedures in so many things, like marriage. You want to get married, you have to go through some procedure. If you want to divorce, you have to go through some procedure. If you want to form a company, you have to go through some procedure. You want to bankrupt, you want to wind up the company, you want to apply for a license. For so many things, there are procedure. Don't think that procedure is only for court action. So nearly everything we have procedure. But court procedure is so complicated. So it's the reason why we have procedural law. So why civil procedure is a separate module. Court procedure, legal procedure are much more complicated than we expect. This is the reason why it's one of the classification in law. And then we go to the legal rules. What is the structure We try to analyze the legal rule more systematically. So legal rules can be divided into two major components. On the left-hand side is called certain fact. On the right-hand side is certain legal consequence. It's something very common sense. Just like the case when you were in the secondary school or even primary school. There are lots of school regulations. Usually, will tell you when you have done something wrong, you will get some consequence. For example, when you are late, if you are late, then you will be punished. If you are late or certain thing, then you will punish the legal consequence. If you do not work hard, then you cannot pass the examination. So it's something so simple. Okay. But when you study law at this level, what can you find? You can find that this part is very complicated. The left-hand side is very complicated. The consequence is still quite simple. But the left-hand side is much more complicated than the school regulation. Usually, school regulation is quite simple. Because if the school regulation is very complicated, just like the ordinance in Hong Kong, no one can understand the school regulation. This is the reason why the school regulation must be simple. Otherwise, no student can understand the school regulation. But when you study the law, you'll find it's something different. Okay. So legal rule is divided into two main components, just like a conditional statement. If so and so, then so and so. Okay. If you attack me, then I will retaliate. If you attack other people, then you will be arrested. Okay. But this part is quite complicated. Later on, I will show you some example. You will see that. So you see the complexity of the legal condition. Very complicated. Okay. Example history club on page 16. Please go to page 16. Okay. We can find some example on the rules of the history club. Page 16. For example, Rule 3 of the history club, any member found smoking in commitment shall be liable to pay the sum of 5,000 or such sum as the committee shall in its absolute discretion think fit. The rule may be reformulated as follows. Okay? Which part is the legal condition? This part. Any member found smoking on club premises is the legal condition. Okay? Usually it's in a statement. It may be one line or even several lines. But usually when you study law, what you have to do? You have to break it down into as many elements as possible. So this one is broken down into three elements. The first element is any member. Second element, found smoking. The third one is on club premises. What is the implication? Why do we have to divide the statement or condition into three elements? What's the function? What's the use? Any member. Because when we divide it into so many elements, you can focus on each element. Okay? When you are reading this sentence, you simply cannot focus on each element. Okay? Sometimes there are so many words, you simply cannot focus on anyone. But now you can focus on the element. What is the significance of any member? What does it mean? It means that you will only be guilty when you are a member. If you are a non-member, will you be liable? The answer is no. You must be a member. So the first element, it may be disputable, is whether the defendant is a member. Okay? If someone is found smoking, do you think the cop can punish him? The cop has to ascertain whether he's really a member of the club. If he is only a worker, if he is only a guest, will he be punished? The answer is no. If a guest is found smoking, he will not be punished. Okay? Because the regulation only say that member. The regulation only apply to member. Okay? The second one, found smoking. Found smoking means that you must be found smoking. 斷正 okay? So if you smoke 1 year before, you will not be punished. If you were not found smoking, you will not be punished. Okay? And also on club premises, what is the significance of this element? The point to dispute is whether this place is club premises. When you were smoking in the street, will you be punished? The answer is no. You must be found smoking on club premises. If you were found smoking outside club premises, you will not be liable. Okay? Usually for the lawyer, they will dispute on each element one by one. They will go through all the elements. They will see whether the client will be found not guilty because of any element. They will go through each element one by one. They will try to find any loophole in the regulation. Please do the activity on page 18. Please go to page 18 and do the activity. Page 18. Please go to page 18, activity 4. It's a reproduction of section 2 of the FAB Ordinance, chapter 210 of the laws of Hong Kong. So we use the same wording. A person commits crime if he dishonestly appropriate property belonging to another with the intention of permanently depriving the other of it. Is the definition of FAB 盜竊 under the FAB Ordinance, section 2. Okay? We change the order. So the consequence comes first. The consequence is a person commit FAB. After the verb if is the legal condition. This one is quite complicated, very long. Okay? So convert the verb into a conditional statement using the if and then formula. Please change the order. Okay? Use if first. If so and so, then so and so. Okay? No need to use different wording. Just change the order, starting with legal condition and then legal consequence. For this section, we start with legal consequence and then legal condition. Please just change the order, using the legal condition first and then the legal consequence. And also count how many elements are there. So for the legal condition, how many elements can be broken down? Try to see how many elements are there for this legal condition. Please do this exercise, even though it's a little bit difficult. First of all, change the order, starting with legal condition and then legal consequence. Please do that. So for English, we can use either one. You can change. You can choose whatsoever order, starting with legal consequence or legal condition. But for Chinese, usually we have to state the condition first. So it's not possible for us to state the consequence before the condition for Chinese. 中文一定係講如果乜乜咁就乜乜乜啊。It's not possible for Chinese to state the consequent first. Also, I try to guess how many elements can be this statement can be broken down into how many elements. Usually, the usual rule is to break it down into as many elements as possible. Some students say 4. Can you give different answer? 3 elements, 4 elements. 3, okay. 6, 4, 5, very good. Later I will tell you the answer. Basically, for this activity, in fact, it's quite simple. No need to change the wording, I think, except a very minor one. The proper answer is that if a person dishonestly appropriate, you just write, copy the wording. Then he commit theft. You have to add the term then, the verb then. So otherwise, no, to make it grammatically correct. No need to change the wording. Because for law, sometimes you change the wording of the legislation, the meaning may be distorted. Okay. So we also say is the answer for this question. Okay, so I think this order is more no. It should be something for Chinese we are more familiar with this order. Usually for Chinese we will state the condition and then the consequent. So it's not possible for us to state the consequent and then the condition. Right? How many? In fact, the right correct answer is 5. Dishonest, appropriate property belonging to another with the intention to deprive it permanently. Of course, no, we do not have a very definite answer, but nearly all the criminal law book will say it's 5. Okay? Why we have to break down into so many elements? Okay? Because we can focus on each element. If you group the element together, for example, you group appropriation together, dishonest, you say dishonest appropriation. It's not something so good because we simply cannot focus on the unique characteristic of each element. So usually the usual practice is to break it down into as many elements as possible because it will be more convenient. For example, why it must be dishonest? Sometimes so the appropriation is honest. For example, you honestly believe that so you can take away the property. For example, you go to an exhibition, you find some leaflet. Usually you take away the leaflet. You cannot be guilty of theft because you honestly believe that you can take away the leaflet, the pamphlet, the booklet. Okay? Usually they are free of charge. Everyone can take it away. Okay? Appropriate. Usually, to put it simple, you take it away. Property. Why we have to say the element is property? Because something is not regarded as property. For example, the air, 空氣 you cannot steal the air. You cannot steal the idea. In Chinese, we have the concept of stealing the idea of other people. But in English law, there's no such concept. If you steal the idea of other people, you may be infringing the copyright. You may be infringing the copyright, the intellectual property. But it cannot be stolen. Idea cannot be stolen, especially for business idea. There's no copyright. Okay? So if you have invented some kind of very smart business idea, there's no copyright. Everyone can copy. So in law, there's no such thing as stealing the idea of other people. 喺法律上係冇偷人嘅意念呢樣嘢嘅。So number 4, belonging to another. So it must belong to another. But whether the property belong to someone sometimes is disputable. So when you study criminal law, you'll find there are so many funny situations. Number 5, with the intention to deprive it permanently. It's also something important. You just take away the property for a short while. Usually it will not be guilty of theft. So you must have the intention to deprive the property forever. It's called permanently. These are the 5 elements. So what happened? What happened if the prosecutor cannot prove all the elements? What's the consequence? If the prosecutor can only prove 5 of them, that's not fair. Low case. Very good. The defendant will be found not guilty. Okay. Sometimes it's very technical. So as we have said, sometimes the lawyer not enough evidence to prove all the elements. One element cannot be proved. So the defendant will be set free. He will be found not guilty. He can leave the courtroom immediately. Legal rules are not enough to describe the legal system. There must be some process. So by common sense, we have 3 different processes. Legislative process, to the process of making law. Judicial process, the process of adjudication of dispute. For example, John and Mary have signed a contract. Now, John does not perform the contract. Mary will sue him. The dispute will be heard by the court. If Mary started the legal proceeding, the dispute will be heard in the court. Executive process, I will put very little emphasis on executive process. We are not studying public administration. So it's something about formulation of policy, administration, or execution of the law. Legislative function, judicial function, and also for legislative function, it will be covered in Chapter 5. Judicial function, it will be covered in Chapter 7. Okay, legislation, legislation and case law are the two major sources of law in Hong Kong, apart from the basic law. The basic law have very important impact on some branch of law, like immigration law, rights of abode, or sometimes criminal law. But it has very little impact on civil law. For example, company law, business law, contract law, it has very little impact. System. So for legal system, it's an entire entity made up of different parts which work together as a whole. General element like legal rules, institution. Institution in this context, it means a branch of law, a law subject. For example, institution of contract means the contract law. Institution of property means the property law. Usually for contract law, we group all the legal rules relating to contract together. We call it contract law. It's a collection of law relating to contract. By grouping so many things together, so our job will be easier. It's easier for you to find the law. It's easier for you to do the legal research. If the law is not grouped together in institution or subject, it will be very difficult for you to find the law. And also process, personnel. Personnel means people. So legal personnel means people who are related to law, like legislator, judges, jury, juror, court interpreter, solicitor, barrister, lawyer, even law clerk, policeman. They are called legal personnel. A set of value and belief is some kind of ideology. For our ideology is rule of law. Of course, there are different people will have different interpretation, understanding of the term rule of law. But rule of law is the ideology of the common law system. In the world, altogether, we have two major legal systems. The common law system, it originated from England, and then it was spread to Canada, Australia, Hong Kong, Singapore, Malaysia. Usually they're English-speaking country or district. So either they are colony or the British or the former colony. Usually only colony or former colony will use common law. For country we have never been colony of England, usually they will not use common law. So when they set up the modern legal system, usually they will choose civilian law. Civilian law is more convenient. Why? Because civilian law, mainly there are some legislation. For legislation, they can be translated very easily. So for example, when China copied the law of Japan, they just translate the Japanese law into Chinese. But if you copy the law of England, you have to, how can you translate all the cases? It's not possible. People that are translating the legislation is easy, but translating the cases are very difficult. So if you want to use common law, you must have a good standard of English. For judges, lawyer, they must have high proficiency of English. So if for someone who has very low English standard, they can never use common law. So usually for those countries who have never been colony of England, usually they would use civilian law. So usually they will just copy the law of some country. For example, China copied the law of Japan, Japan copied the law of Germany. Taiwan copied the law of Germany. So they did not have to know Germany. They just translate. They just ask some legal expert to translate the law of Germany into their own language. So just like the case of Macau. Macau used the law of Portugal. Now after 1999, they use the Chinese version. They translated the law of Portugal into Chinese. That's all. But for common law system, all the legal personnel, all the judges, and also lawyer, they must have very high proficiency of English. Otherwise, they simply cannot use common law. Hong Kong use common law. So we have two major sources of law. Apart from basic law, is the case law, cases, and also legislation. For cases, you can find the cases in the website of the judiciary. For legislation, you can find the legislation in the website of e-legislation. In some branch of law, like contract law, tort law, we only have very little legislation. Most of them are by case law. But in some other branch, it's just the opposite. For example, company law, so it's mainly by legislation. So the form of the common law, so characteristic of the common law legal system. The form is case law developed as a byproduct of the process of the adjudication. When the party have dispute, for example, divorce, land dispute, or contract or tort, the party went to the court and asked the judge to adjudicate the dispute. The judge will make the decision. For example, the plaintiff win the case, the defendant lose. When the plaintiff sue the defendant, the plaintiff won and the defendant lose in the case. The defendant have to pay a compensation of $1 million to the plaintiff. It's the decision of the court, right? But the most important thing is that when the judge made the decision, the judge had to explain the reason for the decision. The reason for the decision is stated in a document called judgment. 判詞 okay? So the document is called judgment. Later on you can find a lot of judgment. In chapter 5, I will give you a sample judgment. You have to go through the judgment and try to understand the judgment. So the judgment, in the judgment, there will be a lot of legal principle. The legal principle will become law. This is the reason why we call it case law, because the law is inside the case. The legal principle is extracted from the judgment. The method is a case-by-case basis. It's very different from legislation. For legislation, the legislature will pass the law. Okay. But for case law, it's a case-by-case basis. Okay. Case-by-case basis means that it was developing gradually. Okay. Usually after a certain year, the law has changed a little bit. So when you study law, usually we will tell you something in the past, maybe starting from the 19th century, or for example, negligence. We started from a case called, say, Donald and Stevenson in 1932, and then in 1960 something, we also have some development. I will tell you the development of the law. Okay, it's a case-by-case basis. So it's a living process which developed by experience and experiment. The number three is process. In the court process, this is adversarial. Adversarial means confrontational, 對立式, okay, or debating, just like a debating. Okay, so when you have a motion, so in a debating competition, we have the government side and also the opposition side. They will have different standpoint. Usually the debating team at the two different sides, they will give the argument in favor of the standpoint. So of course you can expect the lawyer acting for the plaintiff will provide a lot of argument in favor of the plaintiff. The lawyer acting for the defendant will provide a lot of argument in favor of the defendant. And also the court proceeding is mainly conducted by the litigant or the lawyer. The judge so has very little interruption. It's what you can see in the movie. Okay, so usually the question is made by the lawyer instead of the judge. the judge seldom asks any question. Most of the questions are asked by the lawyer, okay? Especially for course examination, mainly is by the lawyer. And the value is rule of law. Please note that rule of law is different but from rule by law. In some countries, they always emphasize law, but they are only rule by law. They just use the law to rule the people, but rule of law. So the law so also restrain the government. The government has to obey the law, but in some country, only the people have to obey the law, but not the government. Legal system applicable to law to Hong Kong, so it's like Mickey Mouse. Okay, so mainly it's by common law system, but we have two very minor elements: the Chinese customary law and also the mainland law. Later on, you will see that the Chinese national law, 14 Chinese national law also apply in Hong Kong. 全國性法律 altogether nowadays we have 14 national law of China also apply to Hong Kong, right? Especially, of course, everyone know that the most important is the national security law for Hong Kong. 港區個國安法 now, please do the revision question before we end the lecture. Please do the revision question and then we'll go through the answer very briefly. No need to write down the answer. Okay, no need to type the answer. And you may write down your answer on your own lecture notes. Okay, but no need to type the answer on chat room. Okay, because otherwise I think it's quite difficult for me to go through all of them. So now I think we can just go through it very briefly. First of all, the two major legal systems is common law and also civilian law. Episode is a very effective way for you to recap what you have learned, to recap the main point of this chapter. Because after a lecture, try to make sure that at least you know the main point. So it's a method I copy from a textbook published by the Harvard University. So I just write down the keyword. I tell you the first three letter to remind you the key concept. So you better not don't refer to the logs. See whether you can recall those keywords. Number two, common law originated from England. So it's originated from England. So in chapter 3, we'll tell you the history. So it originated in the 11th century. So it has a very long history, usually 1,000 years. Number 3, Hong Kong is using common law system. So that we are using common law system. Okay. So the two major sources of law in common law system are called cases and also legislation. These are the two major sources of law. In the next chapter, in chapter 2, we will learn more about the difference between common law and also civilian law. Civilian law is also called civil law. 民法系統the term civil law has two meanings. It may mean one of the major legal systems in the world. It's used throughout all the European countries. This is the reason why England, why Britain is so different from other European countries. Because England is the only country using common law, but all European countries, including France, Germany, Belgium, all of them use civilian law or civil law. Civil law also means a major branch of law is in contrast with criminal law. So the term civil law has two meanings. Okay? Law is simply more law, true or false. So it should be false. Because later on you know law is different from moral teaching. Sometimes we don't have the legal duty, but we may have the moral duty. Why we use a concept in law? Because law is more definite. Moral teaching, moral standards sometimes is not so definite. Okay? Different people will have different moral standard. Okay? Some people think that they have to take care of the parents. Some people think that they don't have the duty. Okay? Some people think that they have the duty not only to take care of the parent, or also the brother and sister, and also the relative, the friend, classmate, etc., etc. Some people have a lot of duty to so many people. Some people think that they don't have any duty to any person. So it's the difference in moral standard. Okay. So this is the other one. So it's the something about fact. So law is a framework. So altogether we have three major framework. The first one is constitutional framework. Okay. Under the constitution, we have substantive 實體法 substantive law or substantive arrangement. The other one is procedure. A procedure is a separate subject. It's something you cannot expect. Most people, especially nowadays, are in the commercial world. Nearly all the procedures are very simple. If the procedures are very complicated, no one will bother to apply for the credit card. Sometimes when you are in the shopping arcade, someone invite you to apply for a credit card. The procedure is very simple. Just give him your ID card and fill in a very simple application form. Okay? Just tell him some simple data. You can get the credit card. and even immediately. They will give you the card immediately. Okay. No, if you give him a very long application form, I think no one want to apply. Okay. The procedure is very simple, but court procedure is just the opposite. Very complicated. One of the reasons is that the judge, they are not businessmen. They don't want so many cases. Okay? They don't welcome litigation. For the businessmen, they always want you to be customer or client. They always welcome you. Because you pay the money. They need your money. But the judge, they don't need your money. Judge is paid by the government. They don't need any business. They don't want to welcome too many litigation. They simply don't want to handle so many cases. They don't want to hear so many cases. They make the procedure very complicated so that they can discourage people from taking legal action. So the mentality is simply very different from the business people. So we have the legislative process, judicial process, and also executive process. But please note that we only focus on legislating and also judicial. We don't put too much effort on executive process. Law settle dispute. True. Law regulates its own creation and application. Also true. Law can be enforced by anyone. False. So especially after you have studied law, you will be more careful. If you enforce the law, it will be dangerous. You may be sued by someone. For example, if you arrest someone, you use force to attack someone, you may be sued. It also happened in mainland China, especially when someone is seriously injured. Okay? Hong Kong use common law is also true. Okay, so I think time management is not too good. Okay. Why is this? Sorry, anything wrong? Number two. So number two. Number two is true. Law regulates its own creation. So you have to follow the law in making law, and also application of law is also regulated by law. In Hong Kong, nearly everything is regulated by law. Sometimes something very minor is regulated by law. Okay. For the government official, they have to make sure that they have the legal authority to do something. For the government officials, from time to time, they have to check the ordinance to see whether they have the authority to do something. Okay. So is what we are going to do for this chapter. For the manual, please note that is something more than enough. Please go through the workbook, chapter 2, and also chapter 3 before the next lesson if you have time. The next lesson will cover chapter 2 and also chapter 3. And also we'll find you also have a lot of activity. Usually you have to do some activity, which makes the lesson not so boring. If I keep on talking, if I keep on lecturing, you will find the lecture quite boring. But now you have the activity, you can apply what you have learned in doing this activity. And also, in the next lesson, we also have an activity on the difference between civil law and common law activity. You learn the difference between common law and also civil law. So of course, we cannot say that common law is better, but say common law is more popular, especially country using common law. They are more influential, like Britain, US, Canada, Australia, say New Zealand, Malaysia, India, altogether. It is they are the most influential country in the world. Okay, so common law is very popular, more reliable. So from the angle of the investor, common law can protect the investor interest much better than civil law. So it's the reason why so many investor and business people they will prefer common law. Right? I think that's all. So I think we will stop here. So in the next lesson, we will learn more classification of law. You'll find the difference between civil law, criminal law, international law, municipal law. Of course, you may choose to have a lookbook on, say, some legal term. You come across so many legal terms. You have to learn the meaning of those legal terms. Please note that so you may need a law dictionary. So if you intend to have legal study for the coming several years, so if you are very serious in the legal study, you may buy a law dictionary. So it's up to you. Okay, so I think I will stop the lecture here. If you have any question, please write it down in say in the chat room. Or if you cannot think of any question, you may give me an email. Don't worry. So we have the recording. So if you have any difficulty in listening to me, so you may listen to the recording. So you have a WhatsApp group. That's good. Student Chen Xin Yan said, can a person in the FAB ordinance be an artificial person like a company? A company usually will not be found guilty, but the officer may be found guilty. The officer of a company, for example, the director, may be found guilty. Any exemptive, it may be too early. But don't worry, we have a say revision seminar shortly before the exam. I think at this stage, just learn as much as possible. Right? No need to consider the examination too so early. My email, so I already I'll give you the. martin.co@hkuspace.hku.hk. Our legal system in New England, New Zealand is also common law. The actual classroom later, it depends on the situation. It may be possible. I hope so. But I hope the virus, so the situation will be improved as quickly as possible. Very good. Thank you very much, Gwen. So glad to do that. You think it's a good lecture. Yeah, we have the recording. Chan Pek Ho. So don't worry. We have the recording. You can listen to the recording in Seoul. I will post the recording in Seoul. Oh, very good. So very good. Usually, student at the very beginning is very enthusiastic. I can also give you this cartoon, this picture. This is what you look like now. First semester, first module, first lesson. This is what you look like. This is what you look like in the last module, last lesson. This is now what you look like. Even though I cannot see you, I know of you look like this. Very energetic, very enthusiastic. Wing Yang Ken. So you look like the latter one. A law of Korea. Usually for mainland or China or some socialist state, usually we have different classification. Some people classify them as civil law. Some people say that is socialist law. 社會主義法制. So it's a combination. China is also the thing. On the one hand, China in the 50s, China was practicing socialist law, 社會主義法制. Okay? But starting from the late 70s, they copy a lot of law from so many different countries, mainly from some civil law countries, like European countries. And also, they learn, they copy law from everywhere. They study land law from Hong Kong. They study commercial law, security law from US. They study law from different countries. So it's very different from Hong Kong. Hong Kong mainly copy the law from Britain, okay? With some exception, but we mainly copy the law from England. But China may not be the case. Sometimes they copy the law from Denmark. Sometimes they copy the law from some European country. PowerPoint, I think PowerPoint is in Seoul. You may log in Seoul and then you get all the lecture notes. Of course, I know if I'm a student, I would prefer to have the. Where can I get the workbook? I think you should contact our EA. Because now we don't have the in-person class. Usually, in the past, we distributed the workbook in the first lesson, but now we don't have any in-person class. So I think please contact the EA to collect the workbook. I think law dictionary. I think if you can find a law dictionary in the internet, I think it's good. But usually I would prefer a hard copy one. So no, I'm old style one. I'm an old style person. I would prefer a hard copy dictionary. Just like English dictionary or Chinese dictionary, I would prefer a hard copy one. You can download the PowerPoint in Seoul. Seoul 2.0. This one, glossary. Please look at Chen Xi Yan. Glossary is something quite different from dictionary. Glossary 對照表. So no, if you have the English term, you have the Chinese equivalent. It's not there's no explanation. There won't be any explanation. We just give you the Chinese equivalent. So it's a glossary. A glossary is good. It's useful. It's also free of charge. Tam Wen Key. Well, sorry. So I don't know why you cannot hear me. The hard copy. I think you can just go to any, say, reputable bookstore. Either you buy the. Later I will give you the name of the dictionary. So I think a Hong Kong one is very good. Of course, we have some English dictionary. For example, this one. But this one is only using the English law. I think we have the someone published by Lexis. But this one is quite expensive. The one published by Lexis is more useful but more expensive because they're using Hong Kong law. This one is only using say English law. So this one is not so expensive. It's around $100 something. Around 11 pound. I don't know, 100 or 200. But it's based on English law, so it may not be too useful. The record of this lesson, so you can find it in Seoul. So our EA will post the recording in Seoul after this lesson, maybe tomorrow. Law dictionary. So tomorrow, the next lesson, I will give you the name of those law dictionary. Any more question? So it's getting late. So no, take a rest. And also we will have another lesson on Thursday. I think the assignment should also be available. It should also be. You can also find the assignment in Seoul. I think it's a little bit too early for us to discuss the assignment. I will leave it until maybe lesson 3 or lesson 4. I'm really grateful for your attendance and also participation. Especially for virtual class is quite difficult to me. I think in-person class is much more easier. Your class is especially good because the response and also participation is very good. Which make my teaching much more easy. Okay, thank you very much. So I think it should be the end of our lesson. So see you this Thursday.